of coverage for Community Associations webinar. I'm Marketing Manager Sherry Branson, and I'm now joined by the President of Kevin Davis Insurance, Kevin Davis.
Hey, Sherry, how you doing?
Hey, Kevin. Good. How are you? Good.
You know what? I am doing great. This is great time for us. Really is.
Yes, it is. And today's a very special date. Today, Kevin Davis Insurance is celebrating 25 years in the D&O liability for community associations industry. And today's the actual date that the company started. Yeah, congratulations, Kevin. 25 years. That's quite an accomplishment. Very exciting. Very exciting. And now we have a very special guest joining us. We have Karen Chervanian, Senior Vice President. Hi, Karen. Welcome to.
Hello there. How are
Hi.
you guys?
Good, good. How are you?
Kevin, can you believe it's been 25 years?
No, I can't. I can't. No.
Like it was yesterday, right?
Yeah, yeah.
Well, first of all, congratulations to all of us for the last, 25 years. Thank you, everybody who's on this, for your support, for your partnership, for sending us business, being our friend, being our client. It's been exciting. It's been a great adventure all these years. And I cannot thank you enough from bottom of my heart. Kevin and I are very happy with all of you guys. It's been a pleasure serving you guys, and thank you again. And that's all. You guys do the rest of the work.
Thanks, Karen. Thanks so much. Thank you. Great
Bye.
seeing you.
Mm.
Bye. Take care. And Kevin, we have a very special webinar for everybody joining us today. We have people coming from all over the country on today's webinar, so welcome everybody. And we're going to talk about how exclusions have really shaped the policy and the industry over the past 25 years. I know you've seen
Yeah,
lots of changes.
I tell you, this is our goal today. We're going to do something that nobody has done before, and nobody even the things we're going to talk about in the next 30 minutes is going to really be. I just haven't heard before. I mean, we're going to look at from the beginning to where we're at today and what we think the future is going to be like for D&O insurance. So it could be fascinating. If you have any questions, any comments, please put them in the chat. We look forward to really getting into a deep dive in terms of the history of D&O for community associations.
Absolutely. And I just wanted to take a quick second to mention that I record all of the webinars and I put them on our YouTube channel. So feel free to visit our YouTube channel anytime. And if you'd like a copy of today's presentation, please send me an email to sherry.branson@amwins.com. I'm happy to send you a copy of today's PowerPoint. And Kevin, no, so let's go back to the early days of the 80s.
Early days. Yes.
This is
All
like
right.
Back to the future here.
This is it. Okay. Wow. Since the early 80s, I will tell you exactly what year it was. I've been handling D&O for community associations. Back in the 80s, this was the best. We had a D&O policy. And now it's the same as was before. We had a claim against the insured for a wrongful act. If 40 years ago, I would say the same thing I say it right now. However, it's evolved tremendously just talking about those definitions. So we talk about claim. Back then, okay, we talk about claim. Today we talk about claim, all how broad the claim is. Back then, a claim was for a written demand for monetary damages and a civil proceeding. It's a lawsuit. So monetary damages only and civil proceedings. Now, what happened was this. Historically, when you had a D&O policy, the D&O policy was called a duty to indemnify policy, meaning that you have a claim, we pay the claim, we pay the part that responds to the D&O after the claim has been resolved. So we indemnification. What we did back then, 40-something years ago, we created a duty to defend policy. What that means is that we had the insurer had the duty to provide defense up front, okay, to which this insurance shall apply. That's the key, to which the insurance shall apply. So if you indemnify it, so you had 5 causes of action, 5 reasons people getting sued. I'm indemnifying. Guess what? The DNO picks up one. The other 4, maybe GL or somebody else. A duty to defend means I step up and provide defense for an entire policy. So what does that mean? What that means is that you duty to defend. So now you're talking about a written demand for monetary damages, or a lawsuit, but also could mean non-monetary damage, meaning that if I'm suing the board because they breached you for your fiduciary duty because I was towed from visitors parking, or I used the pool hours late, guess what? They have to defend, they have a right and duty to defend that claim because insurance applies to it because of breach of fiduciary duty, period. So that was the number one thing. So definition of claim happens to be broader because of duty to defend, something that we never thought about. Written
Mhm.
demand for monetary, those two things now just broaden to non-monetary damages.
Mhm. The industry was so new, Kevin, right? Everything was so new that it was such
Everything
a
was new.
broad policy. Hmm.
Everything was new. So that was number one. The second thing that happens, we're talking about a wrongful act. Now, historically, when we talk about a wrongful act policy, it was like a E&O policy, errors and omissions, misstatements, misrepresentations, the oops moment. But then what happened is we used the word any act in front of it, meaning that any act, error, omission, misstatement. That word any act meant everything. Okay. So duty to defend, you have a right and duty to defend every claim to which insurance shall apply. Okay. You have wrongful act means every act. Okay. Then the best part about it was the insured. The insured was any past, present, future board members, committee members, volunteers, and one more thing, and any other person acting at the direction of insured.
Okay.
Now,
Can you define any other person, Kevin? Define that for
that's
people joining us today.
yes, that was the key. So when you look at that definition, you say it's okay. I said the wording was any other person, but not any other natural person.
Mm.
So we had a famous lawyer. And this is what happened in the late 80s. The CAI lawyers, the Steve Marcuses, the George Nowaks, the Richard Kennedys, started looking at our policy and saying, wait a minute, if you say any other person, that means management company, because a management company is a corporation and considered a person.
Hmm.
That's when the management company started being covered in the policy because we didn't say natural person, we said person. So
Interesting. So
yeah,
that was the turning point. That was the
that
turning
that's the
point.
turning point. So D&O in the 80s, broad contract, but no claims, no claims. But this, like I said, the CAI lawyers out there, they know who they are. They kept coming back and saying, wait a minute, what about this? What about this? To the point where that policy was so broad that then the 90s came. And guess what happened in the 90s?
Mhm. That's when the big claims started coming in. Big
The
claims.
$1 million claims started coming in the 90s.
Hmm.
The 90s, the D&O policy was almost destroyed. Okay, let's start with the first one, property damages claims. Okay, and the biggest one in the 90s was construction defects. Okay, so back before we had a exclusion on it, the property damage and bodily injury was a four. So if you sued for bodily injury or for property damage, not covered, covered under the GL policy. But what happened under the D&O was this construction defect. The board breached their fiduciary duty because the board failed to adhere to the maintenance contract, the maintenance agreements outlined in the documents. So
Hmm.
now I'm saying you have a breach of fiduciary duty because they did not do their job properly, which is the reason why there's cracks in the foundation. The balconies are not being done right. So that was the issue. So all we're getting hit with construction defect litigation lawsuits in the hundreds of thousands of dollars. So you had $100 million buildings going down. We had a $1 million D&O policy back then. And because it said for property damage, when that breach of fiduciary duty came in because the board failed to honor the maintenance contract, the maintenance agreement, maintenance policy, the maintenance agreement, they stopped it. You saw lawsuits. Then what happened after that, after construction defects, now it ran into other maintenance issues. So all of a sudden now, yeah, guess what's happening? The railings are loose. You know, the roof's not being taken care of. The landscaping hasn't been done. Okay. And it goes back to the same thing. Breach of fiduciary duty because the board fails to adhere to the maintenance policies as outlined in the documents.
It just kept growing and growing.
It
It
kept
kept getting
growing and
bigger,
growing,
bigger and bigger. Hmm.
bigger and bigger, because we use four. So the
Hmm.
claim wasn't for property damage. It was a breach of fiduciary duty because the board failed to do something.
Hmm.
Okay. So that's number two. The next one, that's number one. Next one is bodily injury claims. So guess what happened with bodily injury claims? we started seeing wrongful deaths, sexual assaults. We've seen all kind of things. The most famous case that anybody who understands community association knows, Francis T versus Village Green Association. This is the most famous case in community associations because what happened was the Francis T complained because they had insufficient lighting in the community association. So she could complain and complain and complain that she was afraid to go home at night. So she eventually went at night. Somebody snuck into her through it was a sliding glass door, if I remember, walked in sliding glass door and sexually assaulted her. She came back and sued the association because the board failed in its duty to maintain in a reasonably safe condition. Okay. So, because back then, all the associations were safe environments, were secure associations. They did not give reasonable safety. Okay. That
Mhm.
started a lot of claims
That
from
opened up
Francis
the that
T,
opened up
Village
the
Green.
door.
It
That
it
opened up.
huge. So now all of a sudden we're seeing bodily injury claims, property damage claims, and this is starting in the 90s. Okay. Then this next one, discrimination claims. One of the most famous ones is Watergate at can't give the full name, but this was a monster of a claim. The, there was a person that was so bad, and the board failed to do something about it, take reasonable care to protect this person, that when went to court, the judge decided that the association had to buy this individual's house, okay, and find a new place for the person to live. Really,
Wow.
really famous case that we were involved in, and it costs a lot of money. Now, we didn't know we were covering discrimination. We thought discrimination was against public policy. It's illegal to discriminate. We felt all these different things. However, what we have to do is protect the innocent insureds. So if all of a sudden you have a group of board members there who acted in, they thought in best interest association, but did not. Now all of a sudden they've been sued. So boom, now we're stuck with another $1 million case. These are all in the 90s. The next one was breach of contract. Breach of contract is interesting because again, we never believed that breach of contract should be covered under the D&O policy. And they never have been, except for we received our first $1 million claim for breach of contract. And it involved a satellite, a cell tower that was done in the 90s. Okay. It wasn't even a cell tower, it might just something else. A huge tower where the association rented space. Association allowed that tower company to rent space in their community association. And people didn't like it. They thought they would get cancer from it, so they forced them to remove it. Well, it cost so much money, and that tower was site specific that it ended up costing $1 million to do it all. And guess what? Back then there was no exclusion for the for future contract, and we didn't think we'd be covered. And this is the reason why. When we talk about the broad, we talk about the broad named and short. We talked about how we picked up past, present, future board members. We also did one thing that no one else did before either. We named the corporation as an insured. D&O historically do not do that. They just name board members and committee members. When you name the corporation enters into a contract, not board members. That's the
Interesting.
difference. That's the
Interesting. So that's
difference.
a big difference. That's a
That's the
huge.
difference.
Hmm.
So we started seeing breach of contract suits. We're saying, wait a minute, why are we getting that? Board members do not enter contracts. The association enters into a contract. So when the association breached this contract, not the board members, then all of a sudden now we're paying breach of contract suits, millions of dollars.
Wow.
And then finally we have criminal acts. Now, again, I said at the beginning, we had a right and duty to defend, right? Right and duty to defend any claim which is coverage to apply. So we had our first criminal acts case, and the criminal acts was really interesting. It was a New York case, and involved window guards. So the board failed to put in the proper window guards. As a result, they were held criminally negligent. And a
Wow.
lawsuit came in criminally negligence. Now, the question is that, wait a minute, our definition of claim is a written demand for monetary damages in a lawsuit, not criminal proceedings. Well, guess what? Because of the duty to defend policy, criminal proceedings was covered under that policy.
Incredible, incredible. And just to Kevin, can you explain to everybody joining us today, window guards? In New York City, you have all the high
Yes,
rises, and
yes,
you used to be able to just open a window,
yeah.
and the
They
window
had a
guard
law,
would
they
prevent
passed the
people.
window guard law. They called the window guard laws, where they have to be installed a proper way. Even the screws have to be a certain way inside there so that a
Mhm.
kid will not fall out the window. So,
Yeah, to prevent
e-
somebody from falling out the window.
exactly.
Okay.
So that was the 90s. At the end of the 90s, the D&O policy was a wreck. The
Yeah.
main carrier that I worked for was gone. So when 2000 started, and now we're looking at putting a policy together that's profitable. What we did, we went to the exclusions. Now we're entering the year 2000 to today.
hmm That's when all the exclusions started popping up, and they realized, wow, we're getting hit with huge claims one after the other. So what can we do about it?
So what we did, we divided it in four sections, starting with one, the absolute exclusion. An absolute exclusion means there where any part of the claim is based upon arising out of directly or indirectly resulting in consequences of any way involving, and then we just list it. Okay. For
hmm
example, start with the property damage. Okay. We talked about maintenance, maintaining the property. We talked about construction defect. If we have an exclusion that says where any part of the claim is based upon rising out directly in consequence of any way involving any damage to destruction or deterioration of property or any use of property, that would take care of it. So that's the first thing we did. Where any part of the claim is based on attributable directly or indirectly. Now things have changed since then, but that was the original. That was what we thought protected us from the property damage claims. We did the same thing on the bodily injury claim, where any part of the claim is based upon rising out directly, indirectly, all those words right there, bodily injury, sickness, disease, or death. Okay. So what we had to do was knock out those first two things. We had to make sure that I don't want to pick up construction defect. I don't want to pick up maintenance. I don't want to pick up any, sexual, any of those things like that. Any kind of assault, any kind of bodily injury at all, it is boom, gone. So that's the first thing that we had to put in absolute exclusions to make sure that if you have a bodily injury or property damage, it's a GL claim, not a DNO claim. I don't care if you breach your fiduciary duty. I don't care what it is. We don't want to pick it up. That's not our thing. Now, is it 100% effective? No, nothing 100% effective, but that was what we wanted to do.
But it helped draw the line a little bit.
It helped draw the line a little bit.
hmm
So the next thing we did was defense only exclusions. And the number one we did was breach of contract. Breach of contract. First of all, we thought about excluding it in its entirety. But we know that board members, they do have to enter into a contract. And sometimes the contract is too long. Sometimes they want to get rid of it. The landscaper, they don't like the landscaper or the property manager. And so we said, okay, let's provide a defense for it, but we're never going to pay another $1 million claim again because of something like that. We'll provide a defense, and that's it. Now, there's other exclusions in the policy, the American Disabilities Act, where we will provide a defense, but we won't, if they come in and say we want to change the ramps and install like gates and everything for the pool, we don't do that. We provide defense and we limit it. Now, it's interesting when it comes to like discrimination because we still haven't figured out a way to get around some of the issues in there, other than just making people aware of the law. And we can always try to go back on is that it's against the law to discriminate. So is you in violation of state statute? There's defense costs there, but we may have to pay judgments. But still, that's kind of tricky. The next area is clarification exclusions. Clarification is interesting ones because what we're saying there is that there's something there that we need to kind of spell out a little bit more. And a perfect example there was noise. Okay. Um, we saw a lot of noise claims in the 90s, nowhere near the $1 million claims, but people don't like kids making noise or elevators making noise or air conditioning units making noise. So what happened is that if you look on the definition of pollution, noise is a pollutant. And
Hmm.
so a lot of those claims started getting excluded from there. And so once you start excluding claims, the lawyers out there, and some of my favorite lawyers, and I hope they're listening today, what they did though is saying, calling it noise, they call it vibration. So the noise wasn't bothering me anymore. It's the vibration that the noise caused that bothered me.
Interesting. I
Yes.
remember we talked about a claim a few years back about a building in New York City, Kevin, that somebody had filed a claim or had complained about the elevator. You
Hmm.
know, they lived near the elevator, and
Yes.
so travelers had to bring in a testing like to test
Yeah, exactly.
vibration,
See,
noise testing, and it got very scientific,
mhm,
to
yeah.
figure out
And
if
that's
it
what
really.
happens. It's interesting because, there's certain decibels the elevator has to go to. If it goes beyond that, that means they breach your duty, and it costs a lot of money. But if you had a noise exclusion in there, you don't have, you're not covering it all. But the lawyer is smart enough to say not use the word noise, so they use vibration. So
Hmm.
we
Hmm.
clarified it and said that, noise is, anyway, we clarified it and kind of took care of it in the policy. Now we just say noise is covered because instead of playing around with it, instead of, well, they're going to switch it anyway. So we kind of fixed the noise part of the policy.
Hmm.
So that's clarification. Situational. Situational exclusions are one of the ones, these are like one of our favorite arrows that we use. We all have our arrows in the quiver that we use. Situational ones that we hear of a new law that's been passed and we are uncomfortable with that law. So what we do is we'll craft an endorsement says any claim arising out of attributable to consequences directly or indirectly, that new law, bam, we don't put it. So one good example was COVID. When COVID came through, even though I didn't think we need one because we had any part of claim rising out of injury, sickness, disease, or death, we thought that was good enough. But you may want to put in a special COVID. We had a special one for Nevada. So we had a lot of we had situational exclusion based on the situation.
Hmm. Hmm.
Okay. Whew, you're wearing me out here. And this is one that everybody hates the most when you are an insured. This is the individual exclusion. This is that one where we look at that one guy in an association, and every association out there has that one guy who has no, um, he doesn't get along with anybody, and he's the guy who looks at all the rules, and he's the one complaining about the rules, and he's the one starting all the lawsuits.
Hmm.
So
Hmm.
when we find out what that guy is, that guy will be excluded. So we will have a Sherry Branson exclusion on there. If you're the one
I
that
start
caused all the
complaining too
problem in your
much in my
HOA,
neighborhood.
yes. If you're the person in your association, your HOA there, that's going around and complaining because your next door neighbor didn't remove his trash cans in 48 hours, or the association pool hours should be longer because you want to do certain things, then we would
Hmm.
have a Sherry Branson exclusion in the policy.
Hmm. Yeah,
So
there was a person I know that was doing that for regarding ramps and things like that all over New York City, I remember.
yes, yep.
Yeah,
Mhm,
yeah.
mhm,
It
yep.
was, yeah.
Mhm.
So he was
So,
basically.
so, so when we enter to the past 25 years, what we have done, basically, and a lot of our competitors are doing the same thing. It's not something exclusive to what we've done, but we look at what the claims are. We look and see what's happening out there, and we craft exclusions around there for one reason. We want to A, keep coverage in effect, okay, and B, make coverage reasonably priced. Because we're able to
Hmm.
do these five things with exclusions, we're able to now have a policy that really, really can respond to the things that need to be responded to. Because guess what? We're still seeing a lot of claims and we're still paying a lot of money. So, so let's talk about the future. What
Absolutely.
happens next?
Now we're going to look at basically what's happening in the future, Kevin, like all these changes. Are you solutions that have popped up? And now we've seen, I think, every year there's some big event that happens that affects insurance, the insurance industry. And of course, Surfside was the huge event that affected D&O insurance and a lot of other insurances as well, property, et cetera. So let's talk about the predictions and emerging trends, that you're seeing over the next few years.
Sure. Number one, you have the associations that now's been around for 35, 40 years.
Hmm.
And they have not collected assessments enough. They have not done a special assessments enough. So they all looking at reserve studies right now, and find out the reserve studies are underfunded. So
Mm-hmm.
guess what we have right now? Issues with failure to maintain the property. We have maintenance issues. It is probably
Mm-hmm.
the biggest areas impacting community associations right now.
Mm-hmm.
The more I have more meetings about maintenance, especially in the insurance part, because from the GL point of view and the property point of view, they're seeing the same thing we're doing from the DNO and the GL part of view. That the insurance policy is not a maintenance contract. Your job to maintain your building. You have to take care of the roofs.
Mm-hmm.
You have to take care of the balconies. You have to take care of the garages. You have to take care of your landscaping. We're not part of that. The DNO's not part. GL's not part. Doesn't want to be part of it. The package doesn't want to be part of it. So the biggest trend right now, and the biggest emerging trend for community association is to make sure that you maintain your property. You got to
Mm-hmm.
do it because you got to increase your assessments. You got to reserve, get a reserve study, and pay attention to your reserves.
Mm-hmm.
That's number one. Number two, discrimination, harassment, and bullying. COVID. This is what COVID left us. What COVID left us was first of all our feeling that we're just not as satisfied. So it's a low level depression since COVID. But
Mm-hmm.
guess what else? Now we're home. We're working from home 2 days a week. And at 2 o'clock in the afternoon, we're doing this webinar, Sherry, right? And guess what?
Mm-hmm.
Somebody, you look outside your window and somebody's playing pickleball, and pickleball is very, very noisy.
Mm-hmm. Mm-hmm.
Mhm.
Yeah, if you live near the pickleball courts, you
Yeah.
hear it all the time. It's loud. Mm-hmm.
And if you have
Working from
children,
home.
so,
Yeah.
so
Mm-hmm.
what happens now is that the people who are complaining and they're yelling and they're saying, guess what? I can't get my work done. I have a
Mm-hmm.
I have a COVID pet. I have a dog that now
Mm-hmm.
all of a sudden I have to go back to work. The dog is barking all day long. You got all these
Mm-hmm.
issues happening that leading to more harassment, bullying, discrimination claims that we've ever seen. And we don't see it changing anytime soon. We still see those things coming up. Okay.
Mm-hmm. Yeah. Many people are still working at home. Many people are still working remotely.
Mhm.
Mm-hmm.
Next area is cyber liability. Cyber liability scares me because sooner or later, one of the lawyers going to figure out a way to monetize the liability part of it. Now, we're seeing a lot of cyber claims, first party cyber claims. Now, we're seeing social engineering, we're seeing wire transfer fraud, we're seeing computer theft, we're seeing employee embezzlement. But right now, you don't see a lot of liability claims because the lawyers out there haven't figured out how to monetize the liability part. They will. And once they find out how to monetize liability, we will see major D&O cyber type claims in the future.
Mm-hmm.
Okay.
Absolutely.
And finally, regulatory concerns. Since Surfside went down, states are looking, and the main thing they want to do is avoid another building going down. So they're all looking at different ways, different engineering, structural engineering, different studies to figure out what can the states do to make sure that the people who live in them are safe and they're safe. Okay.
Mm-hmm.
And
Mm-hmm.
life safety issues are intact. Those are concerns of ours because, again, when you start having regulations, you got to have people who are going to enforce them. You got to have, administrative, becomes administrative nightmare. But again, these are our concerns. These are our worries for the future. Um, my job is to make sure we're on top of it so that when they come, we're making sure that we are rating correctly for these exposures. Okay.
Mm-hmm.
And the ones that we want to exclude, get excluded. Now, if our competitors want to cover some of these things and we don't, well, guess what? We'll be around for another 25 years from now. Now, I don't necessarily think I'm going to be here 25 years from now. Sherry, you may be here 20,
The
but
50th anniversary will be so.
exactly. But Kevin Davis Insurance Services will be here because what we
Mm-hmm.
do is we make sure that we understand community associations,
Mm-hmm.
what goes wrong in community associations, and we have the coverage that allows us to help them out. But we also allow that we also can say, guess what? Under these conditions right here, no, we can't help you. We're not here. It's not our job. It's not our policy designed to pick up those type of claims. Your general liability should pick it up. Your umbrella may be able to pick it up, but we don't. That's not what we designed for. That's not what our policy is designed for.
Mm-hmm.
So,
We have to be prepared. We
mhm,
have to be prepared for the changes.
mhm.
Absolutely. I did want to take a second to mention again, if you'd like a copy of today's PowerPoint, please send me an email to sherry.branson@amwins.com. And I do see that a couple people typed in questions in the Q&A box. If you think of any other questions, feel free to type them in, and we'll go over your questions at the end. Thank you so much. And now Kevin,
What's
claim
the end? We're at the end.
we're at the end. I
So
can't
what does all
believe
this
it.
means?
Wow.
What does all this means, right?
Ex- Exactly. And we're going to talk
Yeah.
about claims are inevitable,
Claims are
especially in
inevitable.
community associations. You and
Yeah.
I have talked about, people putting flags in front of their house. You've got people with large dogs, with pets. You've got all kinds of situations going on, people working at home more, working remotely, COVID happened, etc. So there are always going to be claims. There are
Yes.
going to be
And
claims.
and and again, our job is to make sure you have a D&O policy that will respond to the claims, and we'll be there for you. You know, there's a lot of insureds out there when that claim comes through, and again, it attacks them personally. This is a board member liability situation where, as a board member, all of a sudden, my next door neighbor is suing me because guess what? I told him that he needed to stop parking where he's parking, or his dog is too fat, or tell him
Mm-hmm,
something that or he shouldn't have a dog at all. And
mm-hmm, mm-hmm,
um, to know you have a duty to defend D&O policy, not a duty to indemnity. And to know you have a broad policy that picks up the insured, and the property manager, where we end up naming the property manager as opposed to saying, well, we. So a lot of changes over the year, lots of changes. Today we feel more comfortable with it because of our knowledge of the industry.
mm-hmm. Absolutely. Many years of experience. And now, yeah, exactly. And it's good to know what exclusions are in the policy. If you have a question, you can speak to your broker about that, your insurance broker, to find out what exclusions are there and explain it to your customers, etc. And you can invite your customers to our webinars. We have property managers, we have board members that jump on our webinars as well. So feel free to invite people as much as you'd like. And now, Kevin, we're going to talk about the risk management helpline, which is provided by Travelers. It's provided by a law firm. It's 1 free hour of risk management advice. It's fantastic. It's a great resource you can share with your board members. The phone number is 855-548-8656. It's available Monday through Friday from 8 to 5 p.m. Eastern Standard Time. So feel free to share this great resource with your customers. And then Kevin has been 3 years now, Kevin, the
No,
podcast.
no, we're on 100 next week.
Oh,
Our
100. Oh,
podcast.
100.
Yes,
Okay.
yes,
Congratulations.
yes.
Congratulations. Yeah,
Yeah.
Kevin's been doing this fantastic podcast called Common Sense for Common Areas. You can get it on all of the places you can listen to podcasts, Apple, Google, Spotify, Stitcher, etc. Kevin, can you talk about your podcast a little bit?
Oh yeah, yeah. In fact, this week, I think this Monday, our 100 episode, and I do once every month. And we take turns, and we go into a little. It's more conversational about what we're talking about today. So, in fact, number 98, which I just finished, is about nuisance. It's about people who are just nuisances in
Oh,
association,
okay.
and they just get on people's nerves. And how do you do that? How do you work with a nuisance?
Yeah,
How do you
yeah,
avoid them from um, really just creating a major problem for community association? Meaning that
right.
just because you're a nuisance doesn't mean you're wrong.
Right, right. Exactly. Yeah,
Yeah, yeah.
exactly. Yeah,
Mhm,
and you have everybody from accountants, you talk about reserve studies, you talk about
mhm,
accounting, you talk about
mhm,
property management aspects
mhm.
of community association. You really cover everything under the
And one
sun.
thing we do every month is have a board hero where we find a person who really went through some struggles and came out on top. So
Oh,
it's really just, if you really want to know about community associations, make sure you attend, subscribe to it.
yeah, yeah. It's
Mm,
great, great resource. Great,
mm,
really
mm,
entertaining as well.
mm.
Fantastic. Thank you, Kevin. And now let me check and see if we have any questions that people sent in today. Let's see. Okay. Okay. Oh, okay. We have a question from Brian Clougherty. Brian asks, are individual exclusions ever removed after a period of time?
Wow. I would say situational exclusions probably are, and individual exclusions, I doubt it. I'm saying no. I would doubt it. I think the exclusions are in there. Once we decide exclusions are on there, it's really rare to say that we could find a reason to take something off because um, if you have an individual or you have a situation that pops up there, those things really do kind of stick with it, and it'd be
They
hard for us
rarely,
to
you
get out.
haven't seen many go away, is
Yeah,
what you.
I've been seeing mental situation going. In fact, things usually get worse because what happens when we find a situation that ends up being something we don't feel comfortable with, that situation doesn't get better.
Yeah, yeah.
Yeah, it doesn't get better. It doesn't get
Right,
better.
right, right.
hmm
Yeah.
hmm
Okay, great. Thank you. Thank you, Brian. Thanks for your questions so much. And now we have an anonymous question. Can you explain claims made coverage versus claims occurrence and the availability of each, as well as differences and advantages, disadvantages?
Oh, okay, I'll make this quick. Okay, this is pretty simple. The D&O policy is a claims made policy, meaning, and your auto policy is an occurrence policy. So if you get in an accident, okay, and if you get into an auto accident and all of a sudden a year later you're starting to feel aches and pains, or even 2 years later, and all of a sudden you start to, oh wow, you start to feel it. So because of the occurrence policy, you put the carrier on notice when the event occurred. Okay. So
Hmm.
whenever the event occurred, there's a policy you have. You go back, okay, well, this happened 5 years ago. Where's my policy at 5 years ago? I even know where it's at. I got to find it. And you put that one on notice. That's the carry, that's their occurrence policy. A claims made policy. I mean, I made a decision 5 years ago. It's not the fund of reserves because guess what? I'm gonna move in 2 years and I could care less about it. So I don't care what happened to reserve. I don't care what's happened to that association. I'm not funding it. Now, all of a sudden, the current board comes in and sues me because of a decision I made 5 years ago. I'm not looking for 5 years ago's D&O policy. I am making that claim today. So the difference is that I don't know any D&O policies out there that are not claims made. So you really don't have a choice.
Hmm.
Okay.
Okay, great. Thank you for that answer. And now we have a question from Howard Hoffman. Thank you, Howard. Thanks for sending in your question. Howard would like to know what is the liability of a board of directors if the management company has employees that are using the building as a side hustle? Interesting. We've never heard this one before, Kevin.
Well, first of all, let's get the name of that building so we can see if we need to non-renew it, or we put an exclusion in that policy for a building that's a side hustle. So we have to have a side hustle exclusion. This is
He says,
it's a very good question, and this is why the D&O policy is so important. Because if you are a
oh,
board, let's say you're not a board member and you don't like what's going on over there, then you make a claim against that board of directors. Okay. If you are a board member, guess what? Somebody gonna make a claim against you because this was happening. Well, guess what? You're gonna say, listen, I'm innocent. I didn't know. I don't know what's going on. That's why you buy a D&O policy. Because the directors and also liability, you're being accused of doing something wrong. You're an insured. A claim is made against you. Please, when that happens, put us on notice. Let us know what's going on. And our job is to respond back to you. So, whenever you have situations like that, also too, you can call that 800, the phone number from school. Scott and Cassandra can help you out. But that's why you have a D&O policy for situations like that we never heard before. But when you get sued, that claim comes in, let us know and we will have somebody respond back to you. So,
absolutely, absolutely. It's important to have the property manager on the policy. This is a great example of that. If the
exactly.
property
Exactly.
management company is
Mhm,
doing a side hustle while
mhm,
they're
mhm.
managing the building.
All right.
Absolutely.
We have to write that down. A side hustle exclusion. Okay.
New exclusion to pop up. Well, great. Well, thank you so much, Kevin. Thank you for a great
Okay.
webinar. Thank you for all the fantastic information. And thank you for joining us, everybody, on our 25th anniversary of Kevin Davis Insurance. And we want to thank you for being customers and thank you for being loyal to us for all these years. We're so happy you've been joining us on all these webinars. And have a great day. And we'll be talking to you soon.
Thanks a lot. Take care, everybody.
Take care.
All right.